I understand the anxiety that you have in your mind because your case is admitted. Now you want to know whether your case will result in success or will result in defeat. You want to get sure about the success of your case. You want to be certain about it. And who doesn't love certainty in life? अगर आपके हाईकोर्ट के केस में हाईकोर्ट ने रूल नाइसाई इशू किया है, or in other words, if we can say that High Court has admitted your case for final hearing, then is that an indication that the chances of success in your case are more? Is it any indication that you are more likely to win the case? Does it ensure victory in your case? Questions of this kind have been asked in the comment box on this channel, and I'll be touching that issue today. दोस्तों, आपको बता दूं कि एडमिशन हियरिंग स्टेज क्या होती है, फाइनल हियरिंग स्टेज क्या होती है, रूल नाइसाई क्या होता है, एडमिट होना क्या होता है, नोटिस बिफोर एडमिशन क्या होता है. All these things have been explained by me in different videos on this very channel itself. And those of you who have not yet understood the same but want to know them, may please go to those videos and watch them. They are easy to find. Separate playlists are made and you can go and just find out those videos relating to admission hearing and all the things. But before I move ahead, it's a moment to rejoice. We are now 50,000 plus. हम सभी 50,000 क्रॉस कर चुके हैं दोस्तों. तो तहे दिल से आप सभी का शुक्रिया. और क्योंकि आपने मुझे हमेशा इनकरेज रखा, मोटिवेटेड रखा, हम सभी यहाँ तक पहुँच पाए. आज हम 50,000 हैं, आगे चल के हम और ज़्यादा रहेंगे. और मैं बस इतना ही चाहता हूँ, मैक्सिमम नंबर ऑफ पीपल शुड कम आउट ऑफ ignorance regarding the law and the legal procedure that is there in the country. I know it's not that easy, but there are certain areas which our people must know, certain procedural things, certain things relating to the intricacies of law, certain danger points. That's what my endeavor has been. मैं हमेशा यही बताते रहता हूँ कि आप कृपया कानून के बारे में सही अंडरस्टैंडिंग रखें, कानूनी प्रोसीजर सही तरीके से समझें. बस आपकी लाइफ में पीस आ जाए, शांति रहे, यही मेरी दिली कामना है. दैट्स माई इनर डिज़ायर. मे योर लाइफ बी पीसफुल. ओके, सो कमिंग बैक टू आवर पॉइंट ऑफ द वीडियो टुडे. तो दोस्तों, जिन दोस्तों को पता नहीं उनके लिए मैं क्विकली बता दूं कि हाई कोर्ट में जब कोई भी केस दायर होती है, उसे पहले एक स्क्रीन किया जाता है एक प्रिलिमिनरी हियरिंग में, जिसे हम कहते हैं एडमिशन हियरिंग. एडमिशन हियरिंग में ये देखा जाता है कोर्ट की तरफ से कि क्या इस केस में डिटेल हियरिंग करने लायक कोई पॉइंट है या नहीं, या हम इसे अपने कोर्ट में दायर करके रख कर सभी का समय वेस्ट करेंगे. Whether it will really be fruitful to have the matter entertained by the court, or should the litigant be shown the door of another court, or should be sent back home. तो ये स्क्रीन करने के लिए एडमिशन हियरिंग चलती है. एंड ड्यूरिंग एडमिशन हियरिंग, if the court gets convinced that yes, there is some point, some arguable point, some important point that needs to be heard in detail, and the court is so convinced that the point is really prima facie good, then the court issues rule naisai. Or in other words, courts केस को admit करके रखते हैं. Admit for what? For final hearing. For detailed final hearing, जो कि कुछ काफ़ी समय के बाद होता है. Now the question is, those whose cases are admitted by the court, will they definitely succeed? Is there any guarantee that they will definitely succeed? Or at least, is there any enhanced probability of success. I understand the anxiety that you have in your mind because your case is admitted. Now you want to know whether your case will result in success or will result in defeat. You want to get sure about the success of your case. You want to be certain about it. And who doesn't love certainty in life? You also want to know that, and that's why this question. Okay, so coming to the answer to this question. Now let me honestly tell you that admitting your case for final hearing is no guarantee of its definite success. This may not really sound sweet, but that's the truth. It is not even an indication that your chances of success have increased. Why I am saying that? I am saying it because even after your case is admitted by the court is going to hear the other side. The court is going to give the other side an opportunity to file its return, to file its reply, and also to hear the other side. So whenever the case will be called out for final hearing, the courts will not only hear the petitioner once again in detail, in greater depth, but equally the court will also hear the respondent in greater depth. And the courts will try to understand the merits of the matter. Courts will try to appreciate the merits of the matter. And the case will solely be decided upon the merits of the case. Now, after hearing both the sides in detail, if the courts do come to a conclusion that the case is more meritorious for the petitioner, then the petitioner may win. Or if the court comes to the conclusion that the petitioner has really no merits, the petition has no merits, but the respondent has a very solid answer to the petitioner's case, then the courts may dismiss the petition also. Or after hearing the parties, if the courts come to a conclusion that some midway should be found, then the court may even pass that kind of order. So the thing to remember is merits of your case. The merits of your case must be very, very strong. Now, what means merits of the case? I have already answered that in a separate video that is available on this channel itself. आपके केस की गुणवत्ता, आपके केस के जो पॉइंट्स है वो लीगली साउंड होने चाहिए. उसे कहते हैं केस में मेरिट्स होना, केस में साउंड पॉइंट्स होना, स्ट्रॉन्ग पॉइंट्स होना. और जब आपके केस में लीगली साउंड पॉइंट्स होंगे, लीगली स्ट्रॉन्ग पॉइंट्स होंगे जो कि आपके फेवर में हैं, तभी आपकी केस जीतने के चांसेस बढ़ते हैं. दैट्स द सोल क्राइटेरिया. नॉट दैट द केस इज एडमिटेड फॉर फाइनल हियरिंग. हाँ, केस फाइनल हियरिंग को एडमिट हो गया है, इसका मतलब इतना ही है कि देयर इज एन आर्ग्यूएबल पॉइंट. There appears to be some substance in what the petitioner is saying. There appears to be some prima facie case in favor of petitioner, but still, I would say, it's not an indication that you are definitely going to win. It's just an indication that you have made out an arguable case, which involves some important point to be gone into greater depths by the court. After hearing the parties, after taking into consideration the law that is applicable to your case, after taking into consideration the corpus of case law of Supreme Court judgments or other coordinate benches of the High Court or by other high courts. After undergoing all that exercise, the court may come to a conclusion that you have a good case or that you don't have a good case. I hope that has answered your question. And to those friends who have asked these questions, I hope you have got the answers to your questions. Thanks for watching.